A rooftop. A wooded lot behind a university building, maybe 40 yards off the beaten path. And on the ground, half covered by leaves, a bath towel, folded around something heavy. Investigators unwrap it slowly. Inside is a rifle. One bullet fired. Nobody at the scene knows it yet, but that towel is about to become the single most important piece of fabric in a death penalty case. Because on it, invisible to the naked eye, are skin cells. And those skin cells are about to be matched against a defendant with a number so large that the human mind can't actually picture it. 1.7 octillion. That's a 1, followed by 27 zeros. Sit with that for a second. We're going to come back to it, and by the end of this video, I want you to tell me in the comments whether that number alone would be enough to convince you. Stay with me, because before we get to that number, we need to go back to a Wednesday afternoon in September, on a college campus in Utah, where a 31-year-old man sat down in front of a crowd of thousands, and never stood back up. This is PalimpSest Crimes. I'm not here to tell you what to think about this case, I'm here to walk through the evidence with you, piece by piece, the same way it was laid out in that courtroom, so you can reach your own conclusion. Before we go any further, if you want to see exactly how a case like this gets built, the subscribe button is right there, and it costs nothing but a tap. Let's investigate. If you're new here, welcome. This channel isn't about telling you a verdict. It's about handing you the actual evidence, piece by piece, witness by witness, and investigating it together, the same way a courtroom would, so you can see the full shape of the case for yourself and land wherever the facts actually take you. Today we're covering one of the most closely watched criminal cases in the country right now, the prosecution of Tyler Robinson, the 23-year-old Utah man charged with the assassination of conservative activist Charlie Kirk. We're going to walk through the shooting itself, the 40-something hours that followed, the manhunt, the surrender, and then, in detail, the evidence that a Utah judge has spent the better part of a week hearing in a preliminary hearing that wrapped up just days ago. Everything you're about to hear comes from sworn courtroom testimony and verified reporting. No speculation dressed up as fact, just the record, laid out so we can go through it together. Let's start at the beginning. Before we go further, if documentary-style breakdowns like this are your thing, do me a favor right now, hit subscribe, tap that bell so you don't miss the September update on this case, and drop a like on your way in. It's the single biggest thing that tells YouTube to put this in front of more people. And down in the comments, I want to know, based on what you already know about this case, do you think the evidence is enough to convict? Type your answer now, and then let's see if it changes by the end of this video. Okay. Let's investigate. Charlie Kirk was 31 years old. He was the co-founder of Turning Point USA, a conservative youth organization he built from a college-aged side project into one of the most influential political operations in the country. Whatever your politics, there's no disputing his reach. Kirk had spent more than a decade crisscrossing college campuses, hosting open debate events where he'd stand in front of a microphone and let any student in the crowd challenge him directly. It was combative, it was polarizing, and it was, by design, incredibly public. On the 10th of September, that format brought him to Utah Valley University, standing outdoors in front of a crowd of thousands as part of his campus tour. He never finished the event. A single shot rang out. Kirk was struck in the neck. Within moments, the open, sunlit quad turned into chaos, students scattering, security scrambling, law enforcement racing to figure out where the shot had even come from. Here's the detail that matters, and it's one investigators would spend the next several days chasing. This wasn't a shooter in the crowd. This was a shooter with a sightline, someone positioned with a clear, elevated view of the stage. And that meant one thing to law enforcement almost immediately: they were looking for a rooftop. Nearby was a building called the Losi Center. It had a direct line of sight to where Kirk had been speaking. And it had a perch, a raised outdoor platform, that gave whoever was up there an almost unobstructed shot. In the chaos immediately following the shooting, officers on the ground did what you'd expect. They treated it as an active shooter situation. Campus was locked down. Investigators combed the area block by block. And it's worth pausing on this, because it's easy to forget in hindsight, once a name and a face are attached to a case, just how much uncertainty existed in that first hour. Nobody had a suspect. Nobody had a motive. All they had was a bullet, a body, and a building with a rooftop. That's where the story of the evidence really begins. But first, a quick word on who Charlie Kirk actually was, because understanding that is going to matter later, when we get into the prosecution's argument about motive. Kirk co-founded Turning Point USA back when he was barely out of his teens, and over the following decade, he built it into one of the largest conservative youth organizations in the country. His signature format was the campus debate table. He would set up on a college quad, invite any student to challenge him on any topic, and let the exchange happen live, unscripted, in front of whoever gathered to watch. It made him enormously influential with young conservatives, and it made him a lightning rod everywhere else. He was, by nearly every account, one of the most recognizable and most polarizing political figures of his generation, someone who built his entire public identity around standing in front of a crowd and being disagreed with, in person, on purpose. That detail isn't incidental. It's the reason he was standing outdoors, unshielded, in front of thousands of people on a college campus on the 10th of September in the first place. It's also the exact detail prosecutors would later try to use to establish why someone might have targeted him specifically, in that setting, at that moment. Hold on to that thought, the idea that his public visibility might be connected to why he was targeted, because we're going to test it directly against the evidence later, when we get into the fight over motive. I'll be honest with you, it doesn't hold together quite as cleanly as prosecutors want it to, and I want you to see exactly why when we get there. Now, back to the investigation. In the hours and days after the shooting, investigators from local law enforcement, the Utah State Bureau of Investigation, the FBI, and eventually the ATF descended on two locations, the rooftop area near the Losi Center, and a wooded patch northeast of campus. On the rooftop perch, the spot prosecutors say the shooter used as a shooting position, investigators recovered a screwdriver. Testimony would later reveal that a former law enforcement officer also described finding what he called a sniper pad nearby, essentially, physical signs that someone had been lying in position for some time before the shot was fired. Then, in that wooded area northeast of the main campus, searchers found something else, a long gun, wrapped in a dark-colored towel. Specifically, and this detail became a courtroom flashpoint later, it was a bolt-action rifle. Bolt-action, for anyone who isn't familiar with firearms, means the shooter has to manually cycle the weapon after every shot. It's not automatic, and it's not semi-automatic. It was chambered for a specific hunting caliber, and testimony would later establish that just one round had been fired from it. Both the screwdriver and the towel were carefully documented at the scene, photographed in place, and then packaged as evidence, the screwdriver and towel going to the FBI's laboratory, and the rifle itself eventually going to the ATF for separate testing. Now, I want to slow down here and actually walk through this with you, because this is exactly the kind of detail true crime coverage tends to rush past, and it's the backbone of everything that comes later in the case. Crime scene response is not a single team walking around with an evidence bag. In this investigation, it involved Utah's own state crime lab, formerly, the Utah Bureau of Forensic Services Crime Scene Response Team, working the rooftop and perch area. A separate but coordinated team covered the wooded lot where the rifle and towel turned up. Every item gets photographed in place, before it's ever touched. That gives investigators a permanent visual record of exactly where it was found and in what condition. Only after that documentation is complete does anyone actually pick the item up. And from that moment forward, it enters what's called a chain of custody, a paper trail tracking every person who touches it, every location it's transported to, and every test performed on it, all the way from the rooftop to a courtroom exhibit table months later. That chain of custody matters enormously in a case like this, because the entire DNA argument we're about to walk through only works if a jury can trust that the towel tested in a lab in the spring is provably the same towel photographed on a rooftop the previous September. Sergeant Fabiola Famina, with Utah State Bureau of Investigation, would later testify in detail confirming exactly that, walking the court through each numbered evidence item, confirming dates, locations, and descriptions that matched what had been documented at the original scenes. At this stage in the investigation, though, none of this evidence had a name attached to it. It was just physical material, a gun, a towel, a tool, sitting in an evidence locker while agents chased leads. That was about to change, and fast, because vehicle tracking evidence and campus surveillance video were about to give investigators a face. This is where the video evidence comes in, and it's some of the most discussed footage in the entire case. Prosecutors say campus surveillance cameras captured a figure on Utah Valley University's campus 4 separate times in the hours surrounding the shooting, before it happened, during the critical window, and again later that night, including one clip investigators say shows a vehicle matching Robinson's car near the scene after midnight, roughly 12 hours after Kirk was killed. The most dramatic footage, though, is the rooftop sequence. In it, investigators say you can see a figure climbing over a railing and up onto the roof, crouching low, moving toward the position overlooking the stage where Kirk had been speaking. Then, after the shot, the same figure is seen running back across the roof, dropping down, and fleeing on foot. This video was played publicly during the preliminary hearing at the request of Kirk's family, and by every account, it was an emotional moment in the courtroom. Kirk's widow, Erica Kirk, was seen watching intently. When the figure on screen dropped low near the edge of the roof, she turned and embraced Charlie Kirk's mother, and the two held each other until the clip had nearly finished playing. Now, and this is important, because it's exactly the kind of thing skeptics online have raised, surveillance footage from a distance, on a rooftop, is never going to look like a crisp studio photograph. It's grainy. It's a build, a gate, a silhouette, a general shape moving across a rooftop. That ambiguity is precisely why prosecutors didn't rest their case on video alone. They needed something more concrete to tie a specific person to that rooftop. And that's where the DNA evidence becomes the centerpiece of the entire case. It's worth pausing here to take the skepticism seriously for a moment, rather than brushing past it, because a healthy amount of skepticism is exactly what a justice system is supposed to invite. A lot of the online discussion around this case has centered on exactly what we just described, that distant, low-resolution rooftop footage is inherently hard to verify with total certainty just by eye. Is the build the same? The clothing? The way the figure moves? Reasonable people can genuinely disagree looking at grainy video alone, and that's precisely why courts don't rely on eyewitness impressions of blurry footage as their standard of proof. It's also, not coincidentally, exactly why prosecutors spent the bulk of the preliminary hearing on forensic and testimonial evidence rather than resting on the video by itself. We'll walk through that evidence in detail in a few minutes, and you can weigh it for yourself. But before we get to the lab results, we need to talk about how investigators even got a name in the first place, because Tyler Robinson didn't get arrested in a raid. He turned himself in. Quick gut check before we keep going. If you're finding this breakdown genuinely useful, smash that like button right now. It really does make a difference in whether this video reaches more true crime viewers like you, and it takes half a second. Okay, back to the case. That single fact has been the subject of a lot of public debate, and it's worth sitting with honestly, because it cuts against the simplest version of a manhunt story. A person who turns themselves in, voluntarily, with their parents at their side and a family friend helping coordinate the process, is behaving very differently than someone actively evading capture. Investigators don't get to ignore that fact. If anything, testimony suggests it shaped how methodically and carefully the interviews that followed were conducted. Nobody was rushing a confrontation, because nobody needed to. One day after the shooting, on the 11th of September, word reached investigators that a young man wanted to turn himself in, roughly 200 miles south of the crime scene, in St. George, Utah. According to testimony from one of the case agents, the call came in around 8:30 that evening. By the time agents made the trip down to southern Utah, coordinating along the way with the FBI, state investigators, and local sheriff's deputies, it was close to midnight. When they arrived at the Washington County Sheriff's Office, they found the situation already unfolding. A young man had come in with his parents and a family friend. He'd arrived around 9 o'clock that evening and was sitting in a soft interview room equipped with audio and video recording, visible to investigators on a monitor down the hall. That young man identified himself as Tyler Robinson. Investigators would later testify to a detail that stuck with a lot of people who followed the hearing closely. He was wearing a dark baseball cap, a burgundy short-sleeve shirt, blue jeans, and gray and white sneakers, a build and description that lined up with what surveillance footage had captured on the rooftop hours earlier. While Robinson sat in that interview room, investigators fanned out to speak with everyone who had come in with him. His mother was interviewed by one team. His father was interviewed by another, simultaneously. A family friend who'd helped facilitate the surrender was interviewed separately as well. All of this happened in parallel, methodically, inside the same building. Robinson was formally arrested in the early hours of September 12, at around 4 in the morning. He was transported to the Utah County Jail later that morning, where his clothing was collected under a search warrant, along with buccal swabs, the cheek swab method used to collect DNA, and a full set of fingerprints and palm prints. That same day, search warrants were executed at 2 locations, Robinson's own residence and his parents' home. The search of Robinson's residence began around 8 in the morning. The search of his parents' home began later that afternoon. One thing that came up directly in testimony and is worth including here, because it's the kind of small procedural detail that ends up mattering a great deal in a courtroom. Before agents from the primary investigative team even reached St. George, Robinson's cell phone had already been seized by local officers on scene. That was the only item taken from him at that point. His clothing, DNA swabs, and fingerprints weren't collected until after a search warrant was obtained, following his transfer to the Utah County Jail the next morning. That sequencing matters, because it shows investigators weren't skipping steps under the pressure of a high-profile case. They were following the same warrant-based procedure required in any case, meaning any evidence collected from his body or belongings would need to survive the same legal scrutiny as evidence collected from anyone else. He was booked into Utah County Jail at approximately 8 in the morning on September 12, with the arresting investigator serving as the booking officer of record, another detail that keeps the chain of custody clean and traceable, start to finish. And this is where another name enters the case, a name that would go on to become arguably the single most important witness in the entire prosecution. Investigators confirmed that Robinson lived with someone else at his residence, his roommate, and, as testimony would later establish, his romantic partner. His name was Lance Twiggs. If you've heard this name before but you're not totally sure why he matters so much to this case, that's exactly what the next section is going to answer. So if you're new here, this is a good moment to hit subscribe before we get into it, because we're about to walk through the single most important piece of testimony in the entire hearing. Before we go further, a quick note on how we're going to handle this next section, because it matters. Lance Twiggs is a private individual who became a witness in this case, not a public figure by choice. We're going to stick strictly to what's been established in sworn courtroom testimony and verified reporting, no speculation about his personal life beyond what's directly relevant to the evidence. Here's what's been established: Twiggs was Robinson's roommate, and the two were also in a romantic relationship. In the days after the shooting, Twiggs cooperated with investigators, and, according to his attorney, speaking to reporters, he has cooperated consistently with the investigation ever since. Twiggs became central to the prosecution's case for 2 separate reasons. The first is physical evidence. When investigators tested the DNA recovered from both the towel wrapped around the rifle and the screwdriver from the rooftop, they initially found genetic material from 3 different people. After Twiggs provided a DNA sample for comparison, an FBI analyst testified that she was able to rerun the analysis and attribute the DNA on both items to 2 specific people, Twiggs, and, with an extraordinarily high statistical likelihood, Robinson. We're going to break that statistic down properly in the next section, because it's the number that's driven most of the conversation around this case. The second reason Twiggs matters is testimonial. Investigators conducted a recorded interview with him in April, months after the shooting, and portions of that interview were played for the court during the preliminary hearing, though the judge ordered certain parts redacted. In it, according to reporting on the hearing, Twiggs described Robinson breaking down emotionally the day after the shooting. He said Robinson started crying, said something to the effect that he wished he hadn't done it, and then kept busy around the house afterward, seemingly to distract himself. Prosecutors also introduced alleged text messages and a note between the two of them. According to testimony and reporting on the hearing, Robinson allegedly left a note that read, in part, that he'd had the opportunity to act against Kirk and that he took it. When Twiggs later texted him asking directly whether he was responsible, Robinson allegedly replied, confirming it and apologizing. Now, it's worth being precise here about something that came up directly in testimony, because it complicates the simplest version of the story you might expect. When Twiggs was asked whether Robinson had ever talked about Kirk specifically, or about gender identity or LGBTQ rights as a source of tension, Twiggs said no. He told investigators he never heard Robinson discuss Kirk before the shooting, and that Robinson didn't talk much about those topics either. That detail is significant, because it sits right in the middle of the next major fight in this case, the argument over motive. It's worth noting that Twiggs's own attorney has been careful to characterize his client's role in all of this. In comments to reporters, the attorney described Twiggs as having cooperated consistently with investigators throughout the case, a detail that matters, because Twiggs was never charged with any crime himself, and nothing in the public record suggests investigators view him as anything other than a witness. That distinction is important to hold on to as we go through his testimony, because it would be easy, given how central he is to the DNA evidence and the recorded interview, to lose sight of the fact that he is not the person on trial here. Because Twiggs was considered such a critical witness, the defense pushed to have him testify in person during the preliminary hearing. The judge ruled against that request. Twiggs testified via the recorded, previously conducted interview instead, over the defense's objection. That's a preliminary hearing procedure. It's a lower evidentiary bar than a full trial, where the rules around live testimony are typically much stricter. Before we go further, I want to explain something important, because it's easy to misunderstand if nobody spells it out. What played out across those 5 days in Provo was not a trial. It was a preliminary hearing, and those are two very different things with very different rules. At a preliminary hearing, the judge isn't deciding guilt. The judge is deciding something narrower. Is there enough evidence here that a reasonable jury could convict, if the case goes to trial? That's a much lower bar than guilty beyond a reasonable doubt. It's often called a probable cause standard. Prosecutors don't have to eliminate every alternative explanation at this stage, just show the evidence is substantial enough to move forward. That's also why a recorded interview, like the one with Lance Twiggs, can be played instead of live testimony here in ways it typically couldn't at a full trial. The rules are intentionally looser, because the purpose is different. This is a screening process, not a final verdict. It's also why the defense's strategy looked the way it did. Robinson's attorneys didn't need to disprove the entire case in this hearing. They mostly needed to preserve their strongest arguments for a future trial, without tipping their full hand this early. That's standard practice, not a sign of weakness on either side. If Judge Graff rules in September that the case should proceed, the next step is arraignment, where Robinson would formally enter a plea. From there, the case moves toward an actual trial, with a jury, a much higher standard of proof, and far stricter rules on evidence and testimony. If this breakdown is useful to you, now's a great moment to hit subscribe, because we're about to get into the DNA testimony, and that's where this case really gets interesting. Okay. Let's get into the piece of evidence that's dominated headlines out of this hearing, the DNA. To understand why this matters so much, you have to understand what prosecutors were trying to prove circumstantially. They had video of a figure crossing a rooftop. They had a rifle wrapped in a towel found in the woods. What they needed was something that could physically connect a specific human being, Tyler Robinson, to that rooftop, and to that gun. DNA is how they tried to close that gap. An FBI DNA analyst named Amanda Backer testified extensively about the results. Here's the process, roughly, in plain terms. When investigators recovered the towel and the screwdriver, they swabbed them for genetic material. Initially, that testing turned up DNA from 3 different people mixed together on both items. But once Twiggs voluntarily provided a comparison sample, a simple cheek swab, analysts were able to rerun their statistical models and essentially subtract his profile out of the mixture, isolating what remained. What remained, according to testimony, matched Robinson's profile with a statistical likelihood large enough that it's genuinely hard to put into everyday language. On the swab taken from the towel wrapped around the rifle, the analysis found the DNA results were roughly 1.7 octillion times more likely to have come from Twiggs and Robinson together than from Twiggs and some random, unrelated person. On the swab from the screwdriver's handle, the number was 30 quintillion times more likely. For context, an octillion has 27 zeros behind it. A quintillion has 18. These aren't just big numbers, in a colloquial sense. They're numbers so far beyond ordinary human experience that population geneticists essentially treat them as a ceiling on statistical certainty, not a literal count of anything. To understand where a number like that even comes from, it helps to know a little about how modern DNA analysis actually works. Forensic labs don't compare an entire genome, the way people sometimes imagine. Instead, they look at a specific set of locations on the genome, regions known to vary a lot from person to person. At each one, they measure the specific variant present. Because these locations are inherited somewhat independently, statisticians can calculate how rare a particular combination would be in the general population. Then they multiply those individual probabilities together across every location tested. When you're comparing a mixed sample containing more than one person's DNA, which is exactly what happened here, the math gets even more complex. The software has to account for every plausible combination of contributors that could produce the mixture observed. That's the modeling analyst Amanda Backer used. Once Twiggs's comparison sample let her narrow the mixture down from 3 contributors to 2. So that eye-watering final number, 1.7 octillion, or 30 quintillion, depending on the item, isn't a measure of one single genetic marker. It's the cumulative result of multiplying probabilities across many independent markers. That's exactly why these numbers grow so astronomically large, so quickly. Under the Department of Justice's own guidelines, analysts aren't allowed to translate that number into a phrase like, "It's definitely him." They're restricted to a specific, standardized description. The results provide what's called very strong support for inclusion. That's the official, permitted language, not certainty, not proof, but very strong statistical support. Now, here's where the defense pushed back, and it's worth walking through their argument fairly, because it's a real, substantive line of attack, not just noise. Robinson's defense team, led by attorney Michael Burt, spent significant time cross-examining the DNA analyst about the limits of what this kind of testing can and can't tell you. And those limits are real. A DNA analyst cannot testify to what specific action left DNA on an object, touching it, wearing it, being near it, or something else entirely. They also cannot testify to when the DNA was deposited. It could theoretically have been there for a long period of time, depending on conditions. The defense also raised the issue of degradation, essentially, DNA breaking down over time or from exposure to heat, dirt, or ultraviolet light. Testimony confirmed that both the towel and the screwdriver showed some degree of degradation, with the screwdriver showing more than the towel. Under cross-examination, though, the analyst was clear that this degradation did not affect her ability to reach her conclusions on either item. A second forensic witness, Jennifer Famuina with Utah's State Bureau of Investigation, corroborated the chain of custody and the recovery of both items, confirming they were the same towel and screwdriver documented and photographed at the 2 scenes. Let's also address a concept that came up directly in testimony, because it's genuinely one of the more misunderstood parts of forensic science: the difference between finding someone's DNA on an object and knowing what that means about their actions. This is sometimes called activity-level testimony, and analyst Amanda Backer was very direct about it under questioning. Her lab has a specific policy that prevents analysts from offering an opinion on what activity actually deposited the DNA, because DNA can transfer in a lot of different ways. Direct contact, like touching or wearing something, is one way. But DNA can also transfer indirectly, sometimes called secondary transfer, through skin cells, saliva, or other biological material moving from one surface to another without direct contact from the person themselves. That's a genuinely important limitation, and it's exactly the door the defense tried to walk through. Under cross-examination, the analyst confirmed she could not testify to when the DNA was deposited on either the towel or the screwdriver, and she could not testify to the specific action, touching, wearing, brief contact, or otherwise, that put it there. What she could testify to, repeatedly and clearly, was the statistical strength of the match itself, that whatever action deposited that DNA, the profile recovered was, at the levels described earlier, very strongly associated with two specific people, Twiggs and Robinson, rather than random chance. So where does that leave things? The defense's strategy, at least at this stage, wasn't to offer an alternative suspect or a competing theory of who else might be responsible. Instead, it focused narrowly on the reliability and interpretation of the forensic testing itself, essentially arguing that a large statistical number doesn't automatically answer every question a jury might have about how or when that DNA got where it was found. The prosecution's response was straightforward: those are exactly the kinds of questions a full trial, with a jury, is built to resolve, not a preliminary hearing. Alright, real quick, drop a comment right now with just the number 1.7 octillion, or 30 quintillion, whichever one actually stopped you in your tracks when you heard it. I'm curious which stat hits harder for people. And if you haven't subscribed yet, seriously, now's the moment, because what comes next is the part of this case that's been dividing opinion the most, the fight over why Charlie Kirk was allegedly targeted. Here's something a lot of people don't realize about how criminal law actually works. Prosecutors are not required to prove why someone committed a crime, only that they did it, unless a specific hate crime or bias-motivated enhancement is part of the charges. Motive isn't a required element of murder. But that doesn't mean prosecutors ignore it. Especially in a case this high-profile, establishing a clear motive helps a jury understand the story, and in this specific case, prosecutors are also pursuing what's called a victim targeting enhancement, a legal provision that can apply additional consequences if a victim was targeted because of a specific protected characteristic or role, which makes establishing motive legally relevant, not just narratively useful. To build that motive argument, prosecutors sought to introduce a written statement from a board member of Turning Point USA, describing the nature of the events Kirk typically held, open debate forums where he discussed, among other topics, traditional and religious viewpoints on marriage, gender, and sexuality, alongside broader political and cultural themes. The defense fought hard against this. Robinson's attorneys argued the statement said nothing directly about Robinson's own state of mind. After all, a document describing what Charlie Kirk believed and talked about doesn't, on its face, prove what Tyler Robinson was thinking. They also argued the statement went well beyond the narrow motive theory prosecutors had floated publicly, sweeping in broader topics like foreign policy and political doctrine that had nothing to do with the alleged motive at all. The prosecution countered that the statement was necessary context, that a jury needs to understand what Kirk's public platform actually was and represented in order to understand why prosecutors believe he was targeted. Judge Tony Graff, who is overseeing the case, issued a measured ruling. He found the statement was provisionally relevant to the victim targeting enhancement and to establishing Kirk's public political expression, while also acknowledging the defense's concerns about it improperly implying Robinson's personal state of mind. His ruling allowed the statement to be provisionally admitted for now, with the door left open to revisit whether it's fully admissible if the case proceeds toward trial. Notably, the statement itself was not read aloud in open court during this hearing. Its content was discussed and argued over, but not entered into the public record in full at this stage. It's also worth returning to something we mentioned earlier, because it complicates the tidy version of the motive story. Twiggs, the person closest to Robinson in the months surrounding the shooting, told investigators he never heard Robinson talk specifically about Kirk before the shooting happened, and that Robinson didn't talk much about gender identity or LGBTQ-related topics either. That's not something that necessarily disproves a motive theory. People don't always articulate their reasoning out loud to the people closest to them, but it is testimony that a jury would eventually get to weigh for itself, and it's exactly the kind of tension that a full trial exists to sort through. Judge Graff's ruling threaded that needle carefully. Rather than fully admitting or fully excluding the statement, he allowed prosecutors to reference it and its general subject matter, while explicitly barring them from reading its contents aloud to the courtroom at this stage. That's a deliberately narrow, provisional ruling, the kind of decision that keeps a door open for trial without resolving the underlying dispute right now. So here's where things actually are, as of this recording. The preliminary hearing ran across 5 days in early July, drawing intense media coverage and members of the public who lined up, some overnight, for one of just 14 public seating spots inside the courtroom. Robinson has been charged with aggravated murder. Prosecutors have stated their intention to seek the death penalty. He has not yet entered a formal plea, and, this bears repeating, he has not been convicted of anything. His defense team has not offered an alternative theory of who else might be responsible. Their strategy so far has centered on challenging the reliability and interpretation of the state's evidence, particularly the DNA analysis. Judge Graff did not rule immediately on whether the case will proceed to a full trial. Closing arguments from both sides are scheduled for September 1st, and it's at that point the judge will decide whether prosecutors have cleared the legal threshold required to send this case to a jury. Kirk's family released a statement after the hearing concluded, expressing gratitude for the public support they've received and describing the week as an important step forward, saying it brought them some comfort to see the evidence laid out publicly. That's the state of the case today. A rooftop. A towel. A number with 27 zeros. A roommate whose testimony cuts in more than one direction. And a judge who now has to decide whether all of it, taken together, is enough to put this in front of a jury. It's also worth talking for a moment about just how unusual the scale of public attention on this hearing has been, because it shapes how this case is likely to be handled going forward. Seats inside the courtroom were limited to 14 for the general public, and people lined up outside the courthouse well before dawn, some overnight, hoping to get one of them. National outlets sent multi-person teams to cover a hearing that, in an ordinary case, might draw a single local reporter. That level of scrutiny cuts both ways. It means every procedural decision, every ruling, and every piece of testimony is being examined closely by legal experts and the public alike, which tends to make judges and attorneys on both sides even more careful about the record they're building, since they know it isn't just going to a jury eventually, it's already being picked apart in real time by a national audience. There's also the matter of the death penalty itself, which raises the legal bar even further. Death penalty cases in the United States typically involve extended timelines, additional layers of review, and, if a conviction is eventually secured, a separate sentencing phase where a jury would need to weigh aggravating and mitigating factors before determining whether execution is actually warranted. That process, if this case gets there, would likely take years, not months. So even a ruling in September that sends this case to trial would only be one of many major milestones still ahead, not a final word on anything. For now, what we actually know is limited to what's been presented and tested in that Provo courtroom: physical evidence connecting two specific people to a murder weapon and a rooftop tool, a recorded interview describing an emotional confession, alleged written and text communications, and a contested argument over what actually motivated one of the most closely watched killings in recent American political history. Everything beyond that, guilt, innocence, the full truth of what happened and why, remains, appropriately, for a jury to eventually decide, if the case gets that far. When you step back and look at everything laid out across this hearing, the surveillance footage, the surrender, the DNA statistics, the recorded interview, the fight over motive, what strikes me isn't that any single piece of evidence is airtight on its own. It's that prosecutors have spent a week trying to weave all of it into one continuous thread. The defense's job, both now and if this goes to trial, is to find the places where that thread doesn't quite hold. That's not a flaw in the system. That's exactly how it's supposed to work. It would be easy to turn a case like this into pure spectacle, pick a side, lean into outrage, feed you only the parts that confirm what you already believe. That's not what we do here. Our job is to lay out exactly what was said, under oath, in that courtroom, the strong parts of the prosecution's case and the genuine questions the defense has raised about it, and let you see the full picture for yourself. A young man is facing a potential death sentence. A family is grieving in front of the entire country. Neither of those realities deserves to be flattened into a headline. We'll be following this case closely heading into that September 1st hearing, and I'll bring you the update the moment there's real news, not speculation, just what actually happened in that courtroom. If this helped you understand the case better, here's how you can help the channel right back, and it takes about 10 seconds. Hit like, drop a comment with your actual read on the evidence, not just, great video, tell me if you think the DNA and the recorded interview are enough on their own, and if you're not subscribed to PalimpSest Crimes yet, subscribe and tap the bell so you don't miss the September coverage. If you know someone following this case through headlines instead of the actual testimony, send them this video. Thanks for watching. I'll see you in the next one.